Chief Justice and the Justices of the Honorable Eastern Caribbean Supreme Court. Supreme Court, in its special sitting to mark the opening of the law year 2022, now opens.
Justices of Appeal, Judges and Masters of the Eastern Caribbean Supreme Court, Their Excellencies, Governors General, and Their Excellencies, Heads of State of each of the OECS member states and territories, Honorable Heads of Government of each of the OECS member states and territories, Retired Judges of the Eastern Caribbean Supreme Court, Honorable Attorneys General of each of the OECS member states and territories, Honorable Ministers of Government of each of the OECS member states and territories, Chief and Senior Magistrates and Magistrates of each of the OECS member states and territories, Honorable Speakers of the Houses of Assembly and Presidents of the Senate of each of the OECS member states and territories, Honorable Leaders of the Opposition of each of the OECS member states and territories, Members of Parliament of each of the OECS member states and territories, His Excellency Dr. Didacus Jules, Director General of the OECS Commission, Directors of Public Prosecutions of each of the OECS member states and territories, Solicitors General of each of the OECS member states and territories, Mrs. Michelle John Thibbles, Chief Registrar, and Mr. Carlos Cameron Michel, Deputy Chief Registrar of the Eastern Caribbean Supreme Court, Registrars and Deputy and Assistant Registrars of the High Court of each of the OECS member states and territories, Mr. Gregory Gerard, Court Administrator of the Court's headquarters, and Mr. Francis Letang, Deputy Court Administrator of the Court's headquarters, and Court Administrators of each of the High Court offices of the OECS member states and territories. Ms. Jean Dyer, President of the OECS Bar Association, Presidents of the Constituent Bar Associations of each of the OECS member states and territories, learned members of the Inner Bar and Outer Bar of each of the OECS member states and territories, members of the clergy, members of the Diplomatic Corps, Commissioners of Police and police officers of each of the OECS member states and territories, Directors, Heads of Correctional Facilities in each of the OECS member states and territories, staff of the Court's headquarters and court offices in each of the OECS member states and territories, distinguished guests, students, citizens and residents of the Eastern Caribbean, good morning. Another year has swiftly come and gone, bringing us to the beginning of a new law year of the Eastern Caribbean Supreme Court. It is an honor and indeed a pleasure to address you once more for the official opening of the law year 2022. I take this opportunity to welcome you all to this special sitting and to also extend best wishes for you for a new year filled with much promise. I pray that as we embark upon this new year, God will bestow His richest blessings upon us all and upon our member states and territories. It has long been tradition for each member state and territory of the court to host by rotation a special sitting marking the opening of a new law year, at which the main feature is the delivery of the Chief Justice's address, with local gatherings in a physical courtroom. However, this was upended by the advent of the COVID-19 pandemic in March 2020, making physical interaction unsafe and prompting many health protocols to be implemented and gathering physically unsafe. This led us to forego the special sitting, which was slated to take place in St. Vincent and the Grenadines in January 2021 in the traditional manner, with persons gathering physically. But all was not lost. We had to reimagine how we would execute the commemoration of the opening of the law year in 2021. We chose to do so in an unprecedented way, up until that time, by means of a virtual special sitting production. That virtual special sitting enabled us to capture a much wider audience as it was streamed live via social media platforms across the region and indeed across the world. It was also aired on UWI TV throughout the region. By all accounts, it was a resounding success. This year's ceremonial opening of the law year was slated to take place in the beautiful territory of the Virgin Islands. I was looking forward with much anticipation to returning to my homeland for this occasion, and because it is the last occasion on which I shall enjoy the honor of doing so as your Chief Justice. But here we are, almost 2 years later, still within the grip of the pandemic. Just as we were beginning to settle into living with COVID-19, given the availability of vaccines and better knowledge of mitigation measures, a new variant has emerged, which has thrown the global COVID-19 situation into uncertainty yet again. This unfolding of events tell us that we are certainly not out of the woods. We must therefore continue to observe all health protocols and remain vigilant as we go about our lives. And so, once more, with the assistance of UWI TV and the use of modern social media platforms, I am privileged to address you virtually on the commencement of our 2022 law year. Crises should never be viewed as all bad. It is in such times that our most creative and imaginative thoughts lead to positive action. Over the last year, the court moved from simply managing the COVID-19 pandemic to developing new and innovative ways of improving the justice system as a whole in light of the deficiencies laid bare by the pandemic. It is the case that the pandemic has created considerable challenges for the administration of justice across the globe, and indeed without exception for the functioning of all courts. It has forced us as a court to see and engage in the virtual world, and in you redefining your views of courts, no longer being seen so much as a place, but more so as a service. The court, and all of us along with it, were pushed into survival mode, requiring it to transform its operations at an even faster pace. In fact, in just over the past year, we have seen the use of digital platforms and other innovations becoming significant and essential features of our court system. This is, for many, a much welcomed transformation. At this stage, the essential question is, what will our justice system resemble in the next 5 or even 10 years? It is, I think, fair to say that as COVID-19 lingers on, and even beyond the pandemic, Digitally driven courts will be critical to the continued administration of justice. Courts around the world have arrived at the same conclusion, that digitally operated courts and services are here to stay, even when the pandemic hopefully becomes a distant memory. Our economic survival requires that we adapt and take full advantage of the ICT revolution. There is no turning back. In looking towards the future and in taking on board what COVID-19 has taught us, the court now seeks to implement new and improved measures to ensure the continuity of its work and the dispensation of justice in and beyond the COVID-19 era. This in turn will involve continued reforms of existing processes and procedures, all aimed at improving the court's accessibility, efficiency, and effectiveness in the delivery of justice in a post-COVID-19 world. Accordingly, a fitting theme for this year's law address is the ECSC Reimagining the Justice System in the Era of COVID-19 and Beyond. The theme reflects the court's sense of duty to the people whom it serves on a daily basis. Indeed, recognizing that a modern and responsive judicial system is at the core of all social and economic development, the court must constantly innovate and reimagine its modus operandi in order to maintain its commitment to providing effective and efficient access to an independent and accountable system of justice for the benefit of all persons within our member states and territories. It is, as the renowned philosopher Francis Bacon said, if we do not maintain justice, justice will not maintain us. We have all had to become comfortable with the concept of the judiciary not being a visual building or place, but indeed a service being provided in many respects invisibly from wherever the place. In advancing our commitment to you, the citizens and residents of the OECS, it is important to first provide you with an update on the work of the ECSC over the last year and the direction being pursued for a reimagined justice system of the future. I begin by giving a snapshot of the work of the court over the last year. In the midst of the COVID-19 pandemic, the closing of borders and national lockdowns, the court remained as busy as ever with a heavy caseload by continuing to provide the needed access to justice system, which was achieved mainly through virtual operations. As an example, at the appellate level, there were 419 appeals filed in 2020. The Court of Appeal heard 351 appeals during full court sittings and a further 437 matters in chamber hearings. The Court of Appeal also delivered 66 written judgments and 258 oral decisions, amounting to 324 decisions delivered in total. These figures are on par with the pre-pandemic data from 2019. A much more comprehensive report on the workings of the court at the High Court and the magisterial court levels is contained in our annual report, which will be available on the court's website. I encourage you to read it so as to gain a deeper appreciation of the court's work at all levels. The expansion of the e-litigation portal. At this juncture, you may be asking yourself, how is the court able to continue dealing with cases? I am proud to say that this is being achieved largely through the court practitioners, and litigants, embracing the use of the e-litigation portal and other ICT technologies. Indeed, a large part of the move to become a digitally driven court is the full implementation of the ECSC e-litigation portal. Last year, the court achieved a significant milestone, the completion of the first phase of implementation of the portal for all 9 member states and territories. Just as recently as October in 2021, we officially welcomed to the portal the final 2 member states of the Commonwealth of Dominica and St. Vincent and the Grenadines. This was preceded by the welcoming of the member state of Grenada in June 2021, making good on our promise to link all the courts across the court's jurisdiction digitally. While this milestone is of even greater significance in the current COVID climate, we believe it is essential for the future of the court in what is no doubt a technologically driven world. Thus, our implementation of the portal does not end there. We are now embarking on the second phase of our rollout of the portal. This phase will see an expansion in the types of matters filed and managed in the portal to include High Court family and criminal matters. I have no doubt that this expansion will be a much welcome development, leading to speedier resolution of cases and greater cost savings to many more court users. Additionally, the second phase is particularly important in light of the adverse impact that COVID-19 has had on the criminal justice system in the OECS, a topic on which I will say more shortly. It is my hope that this second phase will begin to take shape in the upcoming months. I am also pleased to announce that plans are currently underway to reimagine the justice system at the magistrates' court level. Many may not realize that the magistrates' courts across the length and breadth of the OECS deal with the majority of court cases. We must therefore never discount the significant role that the magistrates' courts play in the administration of justice in our region. As such, efforts are ongoing to expand the portal to accommodate matters filed in the magistrates' court during the second phase of implementation. To this end, rules are being drafted for e-filing and e-serving of complaints at the magistrates' court level, and to otherwise guide the use of the portal in a manner best suited to the summary nature of the magistracy. We are also making provisions for the conduct of remote hearings for magisterial matters, which in the member state of Grenada and the territory of Anguilla require immediate legislative amendment in order for this to be possible. This simply means that those member states and territories which do not yet have video links established in their magistrates' courts are encouraged to be quick in putting these in place. I recognize, of course, that the magistrates' courts, too, have not been spared by the COVID-19 pandemic, with their operations having been severely hampered over the last 2 years. It is therefore my hope that these plans to bring the magistrates' courts onto the portal come to fruition sooner rather than later. The simple truth is that we must never become tired in our quest to widen and deepen the avenues of accessibility and accountability for the benefit of our societies by reimagining how these goals may be achieved in times of crisis, with enduring benefits far beyond. The conduct of remote hearings. The court has also managed to deal with its caseload over the past year through conducting many of its sittings remotely. By all accounts, remote hearings have worked well for the Court of Appeal, which only missed one of its scheduled sittings at the very onset of the COVID-19 pandemic. User-friendly video conferencing platforms such as Zoom, coupled with the e-litigation portal, have enabled our courts to transition fairly smoothly to the conduct of remote hearings. The civil and commercial divisions of the High Court in particular were very much open for business. Criminal courts have also been using digital platforms and prison video links to conduct case management conferences and bail hearings. Some member states and territories have been able to use a blended approach of in-person attendance and virtual platforms for the conduct of trials for certain offenses where appropriate. While remote hearings have indeed have proved to be quite useful in the COVID climate, there are some shortcomings which require more attention. Going forward, we hope to fine-tune the conduct of remote court hearings. Quite apart from the challenge of maintaining the solemnity of court proceedings, one of the concerns raised by members of the bar and the bench is that of ensuring the integrity of oral evidence given by witnesses from an out-of-court or remote location. It is critical that measures be put in place to ensure the integrity of evidence given remotely so as to minimize witness coaching or other forms of witness tampering. The duty lies on a judicial officer as part of their case management powers to be satisfied that the directions given for the conduct of remote hearings, including the location from which a witness can give evidence, satisfactorily address these and other concerns which may impact the quality of evidence given in a matter. One measure being contemplated for the purpose of giving the court more effective control and monitoring of the process is to designate rooms at the High Court from which witnesses can suitably give evidence, and in respect of witnesses overseas, by identifying a suitable, designated, and neutral venue for the taking of evidence. Courts across the globe, including those in the United Kingdom, have implemented such measures, and it has enjoyed tremendous success. It is my hope that this court will also see the expanded use of these measures. The Emergency Measures Practice Direction. Our region is particularly susceptible to natural disasters such as hurricanes and volcanic eruptions. Added to those is the likelihood of a pandemic. It is well known that in the midst of the current pandemic, our member state of St. Vincent and the Grenadines experienced the eruption of the La Soufrière volcano. We thought it fit to have in place an emergency plan for enabling a measure of continued court operations. And so in April 2021, we revoked the COVID-19 Emergency Measures Practice Direction number 5 of 2020 and issued the ECSC Emergency Measures Practice Direction number 1 of 2021. This new practice direction is broader in scope than its predecessor and seeks to regulate the practice and procedure of a court which has been affected by a situation, occurrence, or disaster. This includes acts of God, force majeure, or any other event deemed by a member state or territory to be an emergency within that member state or territory, which impacts the operations of the court. This practice direction also contains provisions which permit the location from which a judge, master, or registrar conducts a remote hearing to be deemed a court for the purpose of conducting court proceedings. What this means is this: a judge physically in one member state or territory may preside over any matter being litigated in another member state or territory. For obvious reasons, This feature makes assigning judicial officers to hear matters in other member states or territories, coupled with the use of digital files and records, quite easy. In many instances, the need for physical travel at great expense and lost time has been considerably lessened. It has proven to be essential to the operations of our court, given its supranational character, occupying, as it does, a single judicial space across 9 member states and territories, which are separated by water. It is therefore safe to say that increased reliance on ICT and related measures will inevitably remain a key feature of a reimagined justice system of the future. I take this opportunity to urge governments to take steps, if not already undertaken, to digitize other records, such as deeds, instruments relating to land transactions, and records relating to civil status in ways which allow for greater security and retrievability, thus reducing the serious losses which may be wrought by natural disasters, while at the same time building overall efficiency. Introduction of criminal mediation. While many may think that the court's quest to reimagine the justice system will be solely through ICT, this is not so. In my opening of the law year address last year, you may recall that I reported on our efforts to promote and re-engineer court-connected mediation with a reissued court-connected mediation practice direction. The new practice direction has facilitated improved access to justice, particularly for unrepresented parties and litigants. To date, our court-connected mediation has been entirely focused on civil matters, but I am now pleased to indicate that we are putting in place a framework to introduce a regime for mediation in appropriate criminal matters. This, we hope, will broaden the scope of mediation as a dispute resolution tool and help to propel it to the forefront as part of our strategy in reducing case backlogs at every level of the justice system. The reform of the criminal justice system. I wish to focus a bit now on the criminal division of the court. There is no question that the pandemic has been devastating to the criminal justice system in the OECS. Jury trials have been stalled in many of our member states and territories, due mostly to our inability to provide the required physical distancing protocols for a jury in many of our courtrooms. In fact, due to the COVID climate, the High Court in the member states, such as the Commonwealth of Dominica, has had to vacate all criminal trials for the period September to December 2021. We also remain mindful of further disruptions which may occur in this new year. It simply remains the case that many of our courtrooms are too small and not fit for purpose. COVID-19 has exacerbated the situation. There has been an increase in the number of persons on remand in already overcrowded prisons. This does not bode well for any state and has serious implications for the maintenance and promotion of the rule of law, and indeed the peace and security of us all. It is disheartening and quite troubling when those accused of inflicting harm and those who have suffered harm find common ground in lamenting the seeming interminable wait for justice. It cannot be gainsaid that the criminal justice system is in dire need of robust reform. As I expressed in my last address, the time is ripe for our governments to assist the judiciary by including in their legislative agendas criminal justice reform measures such as provision for the implementation of judge-alone trials for specific CAPE types within the context of the constitutionally guaranteed right to a fair trial. This mode of trial has been tried and tested in other courts in our region. Further, when one considers the plethora of criminal offenses triable by a magistrate, there can, in my view, be no compelling or objectively reasoned opposition to its implementation. Taking such measures would go a long way toward reducing the backlog of criminal cases in the OECS, with no adverse effects on the fairness of the trial process. I pause here to commend the government of Antigua and Barbuda as being the first of our member states and territories to implement judge-alone criminal trials in the High Court. This was due to the swift work of the Registry of the High Court and the Bar, working with the government to implement the necessary legislative framework for this purpose. I also wish to commend the efforts of the government of St. Lucia, which is in the process of drafting legislation to put such measures in place. I urge other member states and territories to capitalize on much of the groundwork done in other member states and territories who are more advanced in these legislative reform processes, as we all seek to improve the safety, security, and by extension, the economic well-being of our sub-region. Another measure governments may wish to adopt, short of abolishing the jury system altogether, is legislative provision for smaller jury panels. Having judge-alone trials or trials with reduced jury panels will have many benefits, including decreasing the expenditure associated with operating a jury system, which ultimately inures to the benefit of the public purse, while boosting efficiency, accountability, and importantly, public confidence in the justice system. The criminal justice system cannot remain at a standstill because of COVID. We must find ways to administer justice despite COVID. I therefore take this opportunity to once more call on the heads of government of the OECS to seriously consider the necessary and urgent legislative reform which will aid the courts in the continued delivery of justice, lest justice takes flight. We all know that economic growth and criminality cannot coexist. The delay in production of transcripts. Another deficiency made more acute by the COVID-19 pandemic is the undue delay in the production of transcripts of proceedings across all member states and territories. In presiding over the Court of Appeal, I observe that far too many civil and criminal matters must be adjourned due to the unavailability of transcripts. In fact, many persons who have launched criminal appeals ultimately end up completing their sentences before their appeal is heard due to the lack of transcripts. In such cases, the Crown often takes the judicious course of conceding the appeal, with the default position on sentence being time served. These delays, on any view, amount to a gross denial of justice. This situation ought not to become normalized, and no one should treat it as acceptable. It is not. Are there solutions which can cure these delays? The answer is yes. We are living in a digital age. While I appreciate that not much can be done about matters of some vintage, it is possible that as courts become more electronically driven, the use of real-time transcripts can become commonplace. Many digital platforms now utilized for remote hearings has this feature built in. The legislative framework across the states and territories simply need to catch up with this reality and recognize that these electronic formats as official records of court proceedings are helpful. I urge all heads of government to enact the necessary legislation which will enable the use of electronic transcripts. I recognize that some may argue that putting such systems in place will come at a cost. However, if it is thought that this is costly, then I ask you to think about the alternative, the inevitable weakening of the justice system and the immeasurable harm to the rule of law. I commend the member states and territories such as St. Lucia, Antigua and Barbuda, and Montserrat, which have already taken steps towards implementing legislation to make digital preparation of transcripts a reality. The other states and territories ought to now pick up the pace. It is simply inexcusable for a litigant to be delayed access to justice for the sole reason that a transcript of proceedings has not yet been prepared. This is most certainly an unjustified limitation on access to the courts, and it cannot be permitted to continue. While I recognize that this move towards the real-time production of transcripts will require some time and support from all our stakeholders to bear fruit, it must be given due priority, as it is an essential feature of any modern justice system. I now want to briefly mention other initiatives that have been formulated by the court with a view to reshaping and enhancing the justice system. When one thinks about any modern justice system in the world, it is taken for granted that all legislation can be found online through a quick and easy search using any search engine. Unfortunately, this is not the case in respect of the courts in all our member states and territories. This deficiency is even more apparent in the current environment when judicial officers and court staff may be required to work remotely. Online access to law resources is now a necessity for the effective daily operations of the court. We will therefore seek to engage in discussions with the Honorable Attorneys General of the member states and territories with a view to having legislation for all member states and territories accessible online. The Civil Procedure Rules Review. In reimagining the justice system, a critical review of court procedure has also taken center stage as we examine whether our civil procedure rules adopted in 2000 are still fit for purpose in this digital age. This review commenced in 2019 under the able co-chairmanship of His Lordship, the Honorable Mr. Justice Paul Webster, Justice of Appeal, and former High Court Judge Professor Eddie Venters, is ongoing. It involves a lot of work. I am happy to now report that the committee is in the final stages of completion of its proposed amendments to the rules. The amended rules will bring about much needed modernization to civil procedure and practice as we know it in this age of electronic filing and remote hearings. I look forward with much anticipation to these rules coming on stream in the upcoming months. I take this opportunity to thank the members of the Rules Review Committee for their hard work and dedication to the task. The Sentencing Guidelines Project. The work of the Sentencing Guidelines Advisory Committee, co-chaired by Her Ladyship, the Honorable Madame Gertel Thom, Justice of Appeal, and His Lordship, the Honorable Mr. Ian Morley, High Court Judge, also continued over the last year. As recently as November 2021, reissued sentencing guideline compendiums covering some sexual offenses, drugs and firearms, dishonesty, violent and homicide offenses came into effect. At the same time, the murder practice direction was reissued. This has brought the advisory committee's work to a close, paving the way for the next stage, which is the establishment of the Sentencing Guidelines Committee, foreshadowed by the Sentencing Guidelines rules. This committee's mandate will be to monitor the effectiveness of the guidelines and propose changes or new guidelines as may be deemed necessary. I am heartened by the extensive reliance by judicial officers and legal practitioners alike on the sentencing guidelines issued so far. Its impact has been felt by us on the Court of Appeal. I place on record my sincere appreciation for the hard and time-consuming work done by the Sentencing Advisory Committee, and in particular, the heavy lifting done by Justice Morley. The Code of Ethics Review. In my last address, I briefed you on our efforts to revamp and modernize the Code of Judicial Conduct governing judicial officers. This work was completed, and I am pleased to report that in June 2021, the revised Code of Judicial Conduct and commentary came into effect for all judicial officers of the court, including magistrates and registrars. The principles set out in the code serve as guidance for the standard of conduct expected of judicial officers in their day-to-day work or during off-duty activities. It includes guidance on a number of matters which have never before been set out in any written document, such as social media usage, a major part of a modern technology-driven society, which the court must navigate. I place on record my deep appreciation to the chair of the Code of Ethics Review Committee, Her Ladyship, the Honorable Kimberly Snack Fulgence, High Court Judge, and the members of the committee for undertaking this significant task. I take this opportunity to encourage all judicial officers to become familiar with the code, as it is truly a useful guide in navigating and managing various challenges bearing on your daily life and duties. The Family Division Pilot Project. Bringing this project to reality has been a monumental task, requiring many stakeholders to work together. I am now able to say that we are nearing the finish line for implementation within the next couple of months in Antigua and Barbuda. The family proceedings rules, which will underpin the court processes in the family division of the court, are at the stage of finalization, with the anticipated date of promulgation of the rules being 1st of February of this year, followed by the division commencing operation a few months later in April of 2022. The committee has also developed a practice direction setting out the forms to be utilized in making applications in family proceedings. For their hard work and attention given to this project, I express my sincere appreciation to the chair of the committee, Her Ladyship, the Honorable Marissa Robertson, High Court Judge, resident in Antigua and Barbuda, and its members. If we are able to continue to modernize the court's processes and put in place the mechanisms made possible by the use of ICT, allowing for even greater accessibility, then it would be true to say that the justice system, notwithstanding the pandemic, but rather in spite of it, has been reimagined in ways which will better serve all the people of the OECS region in ways that will ensure its sustainability, efficiency, and accountability. These in turn will promote public confidence and sustain the court's authority in our perennial quest for a more just society. Before closing, permit me a few indulgences. Firstly, allow me to officially welcome the new judicial officers appointed over the last year. I welcome His Lordship, the Honorable Justice Patrick Thompson Jr., who was appointed as a High Court judge assigned to St. Lucia in January 2021. His Lordship, the Honorable Justice Colin Williams, who was appointed as a High Court judge assigned to Antigua and Barbuda in March 2021. Her Ladyship, the Honorable Justice Jan Drysdale, who was appointed as a High Court judge assigned to Antigua and Barbuda in April 2021. Master Sharon Gardner Hippolyte, who was appointed as a master in May 2021. And Master Alvin Pariak Singh, who was appointed to act as a master in the same month. I am delighted to officially welcome you all as members of the Eastern Caribbean Supreme Court, some of you having provided tremendous assistance to the court during previous acting appointments over the years. I also wish to extend my gratitude to the many legal practitioners and retired judges who have assisted the court over the last year by taking up acting appointments to fill voids on the bench. Echoing the words of King George VI, the highest of distinctions is service to others. Secondly, allow me to also place on record our appreciation for the continued support of the OECS Bar Association and the constituent bar associations of the Eastern Caribbean. I am especially pleased that all the continuing education efforts undertaken by the associations for the benefit of its members. I foresee that ICT proficiency will become an added qualification of legal training. I encourage you to keep up the good work and to never flinch from your duties in taking the hard decisions which are necessary at times to preserve and maintain the integrity of the legal profession for the due administration of justice. Permit me also to convey my sincere gratitude to our cohort of judicial officers for their tremendous efforts over the course of last year. Surely you have all gone above and beyond. This last year was a difficult one for many of us. Some of us separated from close family and relatives, and thus beyond our normal solitary life. Yet, we have persevered to see to it that you, the public, were not shut out in seeking to obtain justice. I thank you for your dedicated and continued service. This year, let us renew our energies and our focus to our tasks and continue to imagine and reimagine ways to make the court more efficient, thereby building a more improved justice system to which all can look and rely on with confidence. I also wish to thank our registrars who have ably managed the operations of our registries during this extremely difficult time, and who continue to liaise with the executive on matters of funding and resources for the smooth operations of the court. In all that we have managed to accomplish over the past year, our stakeholders, partners, and donor agencies have been there alongside us, providing much needed assistance. On behalf of the entire judiciary, I express sincere thanks to the teams from the Jurist Project, Impact Justice, the United States Embassy and the British High Commission, the University of the West Indies, UWI-TV, UNDP, the governments of our member states and territories, as well as all those not specifically mentioned, for their continued support of the Eastern Caribbean Supreme Court in our mission to provide access to a system of justice that is fair, efficient, and accountable. Finally, I express sincere gratitude to every individual who has contributed to the court's continued success over the last year, in particular, our staff at the court's headquarters and in the various high court registries, members of the public and private bars, the police, as well as the people of the OECS whom we serve on a daily basis. I pray that the Almighty will keep us all safe through this challenging period, and that He will instill with us the courage and resilience to persevere. I once again thank you for your support of the court as it journeys toward a reimagined justice system for the OECS. And I thank the governments and all member states and territories, and you, the people, for giving me the great honor and privilege of being a part of that journey over the last 9 years. May the Eastern Caribbean Supreme Court go from strength to strength. Thank you. I now hand over to our Master of Ceremonies, Her Ladyship, the Honorable Vicky Ann Ellis, Resident High Court Judge in the Territory of the Virgin Islands.
Good morning, and welcome to this special sitting marking the opening of the law year 2022. I am Justice Vicky Ann Ellis, Resident High Court Judge in the Virgin Islands, and your Master of Ceremonies for this sitting. As intimated by the Honorable Chief Justice, this year's opening would have been held in the Virgin Islands had it not been for the COVID-19 pandemic. And so, here we are for another year and another opening, embracing technology and using it to bring us together, despite our geographical divide and the unavoidable physical restrictions imposed upon us by COVID-19. Having just heard the feature address from the Honorable Chief Justice, I have no doubt that you would have all been refreshed and inspired. At this juncture in these proceedings, we will now hear from the members of the public and the private bar of each of the member states and territories of the OECS. Our first speaker from the bar is none other than the Honorable Don J. Smith, Attorney General of the Virgin Islands. Honorable Don J. Smith was admitted to practice as a barrister in the Virgin Islands in 1997. In private practice, she specialized in commercial litigation. She has held many positions in the public service, including General Counsel of the BVI Financial Services Commission, Director of the BVI London office, and a permanent secretary in the Office of the Premier. On the 1st of October 2020, she was appointed Attorney General of the Virgin Islands. To address us on behalf of the Attorneys General and as the representative of the Virgin Islands, the Honorable Don J. Smith.
Good morning. I adopt a protocol list which has already been established. However, permit me to recognize Her Ladyship the Honorable Dame Janice Pereira, Dame Commander of the Order of the British Empire, Doctor of Laws, and our Chief Justice. Their Excellencies, Heads of State of the OECS, the Prime Ministers, Premiers, and Chief Minister of the OECS, Judges and Masters of the Eastern Caribbean Supreme Court. I should first say how humbled I am to represent the Attorneys General in the Eastern Caribbean Supreme Court jurisdiction and the Bar of the Virgin Islands at this virtual opening of the 2022 law year. For some years now, we, the legal profession in the Eastern Caribbean, have pushed the boundaries of the practice of law and dispute resolution. Most recently, we have adopted to remote access for the conduct of case management conferences, hearings, and other interactions in the dispute resolution space, as we have braved extreme natural disasters and a global pandemic. My question today is simply, where do we go from here? Not too long ago, the 26th Conference of the Parties concluded in Glasgow, Scotland. There, world leaders acknowledged that climate change is a common concern of humankind, and among other things, also acknowledged the important role of a broad range of stakeholders at the local, national, and regional level in averting, minimizing, and addressing loss and damage associated with the adverse effects of climate change. I congratulate our Chief Justice on her steady and visionary leadership, and I also congratulate the Eastern Caribbean Supreme Court bench and bar for their resolve to follow her into the digital age. I urge us not to downplay the significance of the steps that we have taken so far when we contemplate the question, where do we go from here? I commend the principles of the Green Pledge to judges, legal practitioners, and all those who support the practice of law in the Eastern Caribbean. For example, create a workspace with a reduced environmental footprint by looking for opportunities to reduce energy consumption and waste. Correspond electronically unless hard copy correspondence is expressly needed in the circumstances, while also being mindful that email has a carbon footprint. Avoid printing. Request the use of electronic rather than hard copies of documents, and promote the use of electronic bundles at hearings. Consider and/or suggest, where appropriate, that witnesses or experts give evidence through video conferencing facilities rather than attend hearings in person. Consider and question the need to fly at all times and offsetting carbon emissions when we do. Most of the principles may sound achievable or even routine to us now because we have been forced to do them to be able to practice our profession in the middle of COVID-19. I am hopeful that things will return to normal, but I want to encourage all of us instead to use what we have had to do over the past 2 years to change the way we live and the way we practice law in the future. We have become better, and some of us experts, at practices that would help us to develop a sustainable relationship with our planet. It will be for our masters and judges in the Court of Appeal to say whether they miss the LL.D days or prefer to interact online. Does it, for example, allow them to see advocates and witnesses better? All over the world, the debates are ongoing about topics such as online courts, best practices in remote advocacy, and how remote hearings impact fundamental rights and freedoms, including the right to the protection of the law and the right to have the environment protected for the benefit of present and future generations. If you are like me, you have toyed with the idea that it makes no sense. We are too little and too few to do anything worthwhile. I now believe that we can do our part, that we can lead by living the alternative, by mainstreaming in our system those actions that, if emulated by other professions in our region and in other parts of the world, would make a real difference. I challenge all of us, in the words of Sir David Attenborough, to make this a time in which we learn how to walk with nature rather than against it. A time in which there would be no longer any great distinction between the natural and the managed, for we would become the attentive stewards of the entire earth calling upon nature's extraordinary resilience to help us bring its biodiversity back from the brink. So as we open the new law year, under the theme, the Eastern Caribbean Supreme Court, Reimagining the Justice System in the Era of COVID-19 and Beyond, I issue this challenge to all of us. And on behalf of all the attorneys general in the Eastern Caribbean, and on behalf of the Virgin Islands Bar, I wish you a happy, prosperous, and productive law year 2022. Thank you.
Our next speaker, the Honorable Vincent F. Byron, is the Attorney General and Minister of Legal Affairs of the Federation of St. Kitts and Nevis. The Honorable Vincent F. Byron was called to the Bar of England and Wales in 2006. In 2007, he was awarded the Legal Education Certificate from the Norman Manley Law School and was called to the Bar of St. Kitts and Nevis later that same year. In 2010, Honorable Vincent F. Byron became a member of the National Assembly of St. Kitts and Nevis when he was appointed as a senator. He has had a long and distinguished professional and legal career and has held the post of Attorney General and Minister of Legal Affairs since February 2015. To address us on behalf of the Ministers of Legal Affairs and St. Kitts and Nevis, the Honorable Vincent F. Byron.
I would like to adopt the protocol which has already been established. However, permit me to acknowledge Your Ladyship, the Honorable Dame Justice Pereira, DBE, LL.D., Chief Justice, Your Excellencies, Heads of State of the OECS, Prime Ministers and Chief Minister of the OECS, Judges and Masters of the Eastern Caribbean Supreme Court, Attorneys General and Directors of Public Prosecutions of the OECS states. I am pleased and honored to bring greetings to the Court at the start of the 2022 law year, along with the distinguished learned Attorney General of the BVI, on behalf of Attorneys General across the 9-member jurisdictions of the Eastern Caribbean Supreme Court. I believe that I speak for all when I say that we believe in the rule of law and uphold the universal principles that the government and its officials and agents are accountable under the law, that the laws should be clear, publicized, stable, fair, and protect fundamental rights, including the security of persons and property, that the process by which the laws are enacted, administered, and enforced should be accessible, fair, and efficient, and that access to justice should be facilitated by competent, independent, and ethical adjudicators, attorneys or representatives, and judicial officers who are of sufficient number, have adequate resources, and reflect the makeup of the communities they serve. We recall the words of the Roman senator, lawyer, writer, and orator Marcus Tullius Cicero when he says that we are all servants of the laws in order that we may be free. Milady, the global COVID-19 pandemic has been with us for nearly 2 years, has been relentless. We have had to deal with surges of widespread transmission of the virus, different mutations and variants, which have put our healthcare systems under great strain, threatening to overwhelm our countries. However, we have been resilient, we have adapted, and in all this, we have not departed from our belief in the rule of law. Milady, we have been grateful for the Court's proactive decision to introduce and implement a number of measures and strategies in response to the COVID-19 pandemic. By these measures, the Court sought to strike the balance of safeguarding the health and safety of the public, judicial officers, and court staff, while maintaining a functional judicial system, allowing access to justice and the proper administration of justice. Electronic means of communication, video and teleconference, have been utilized, where feasible, to conduct hearings in each of our member states and territories. Practitioners working remotely from their offices and other locations have appeared before judges by electronic digital link, such as Zoom, set up by the court office. The court's use of technology, and in particular, the electronic litigation portal, continue to pay dividends during the past year. We continue to file matters online, and there has been the facilitation of remote hearings. From January 2021 to the end of November, here in St. Kitts and Nevis, there were some 196 High Court matters filed in the Civil Court, and 17 matters along with 24 depositions in the Criminal Court. There were 36 matters appealed to the Court of Appeal. The statistics also show that some 92 probate matters were also filed. We note also that some 18 matters were sent to mediation, 3 settled, 8 unsettled, and 2 require further consultation. We continue to encourage litigants to seek this course of action, which allows matters to be settled in a timely and less costly way. In the Supreme Court, all criminal matters are jury trials, and the court cannot sit without the physical appearance of jurors. The lockdowns mandated to combat the spread of the COVID-19 reduced the ability of the court to maintain its disposition rate, which consequently is lower than it would have been in normal times. The Ministry of Justice anticipates that the vaccination rate in the Federation, resulting in minimizing the incidence of lockdowns, will permit the rate of jury hearings to increase during the new law year. In March 2021, Mr. Justice Morley QC was appointed to serve in our jurisdiction. He has been assigned to the St. Kitts Circuit, replaces Mr. Justice Ventos, who demitted office at the end of 2020. Justice Morley QC joins Mr. Justice Ward QC in St. Kitts and Mr. Justice Moise in the Nevis Circuit. Justice Morley sits primarily on criminal matters. We commend the masters who have served over the last 2 years. Though not conducting in-person hearings, they have dealt with all matters that were put before them in a timely manner. Milady, the summary court has functioned, for the most part, during the pandemic. Due to the COVID-19 pandemic, the country was on lockdown for the period 14th June to 11th July 2021, and therefore there were no cases filed and no trials conducted. In order to cope with the challenges of COVID-19, Zoom hearings have been introduced in the Magistrates Court since January 2021. Zoom allows a full list to be scheduled where ordinarily it is not possible. Lawyers remain in their offices with their clients for court hearing via Zoom. Sessions conducted via Zoom include evidence taken from witnesses who are overseas, evidence taken from persons in wheelchairs, civil call-over twice monthly. All contentious matters are adjourned for trial in court. Zoom has been a tremendous help in eliminating the backlog caused by numerous lockdowns. Starting in August, a night court has also been introduced in District A. It has been a tremendous success. Approximately 360 matters, primarily traffic matters, have been heard. It is favored by the litigants because they do not have to take time off from work to attend court. And legal aid clinics held by the Legal Aid and Advice Center, which provides legal assistance to the indigent, were greatly reduced from an average of 15 per year to only 4 due to the pandemic. However, while legal aid clinics were reduced, clients at the Legal Aid Center have increased. There was a vast increase with persons coming to seek legal advice and legal services at court or otherwise, regarding employment law issues, domestic violence matters, child maintenance arrears, spousal maintenance arrears, and numerous landlord and tenant matters. During this challenging period, the Ministry of Justice and Legal Affairs continues to give support to the judiciary and judicial institutions as well as to provide various legal services to practitioners and the general public. Over the past weeks, the annex building to the main court building in the Salih Moore Judicial and Legal Complex has been commissioned. This new edifice houses a third magistrates court chamber for District a mediation center, and a new law library. The new magistrates court chamber will complement the work being conducted in the two other magistrates court chambers in the main court building and will be dedicated primarily to in-camera, juvenile, and family court matters. Court-connected mediation matters can now be consistently scheduled and will alleviate the challenges experienced before due to the lack of dedicated meeting rooms. There is also dedicated staff to preside over mediation, which we hope will help to reduce the number of matters going to trial and allow litigants to receive justice in a timely and cost-effective manner. It should be noted that earlier this year, a second cohort of mediators, included lawyers and individuals from an array of professions, were trained under the auspices of the court, and we now have some 15 individuals on a roster of mediators, up from the 2 mediators who had performed the yeoman service over the years. The new law library is a significant investment and the first specialized public library in the Federation, and for this we are duly proud. With the advent of this library, practitioners and litigants in person, students, and the general public will be able to utilize online search engines, law journals, and various specialized law books. There will also be a reading room for persons who wish to sit quietly and conduct research. We record our thanks to Professor Velma Newton and Impact Justice for the assistance provided in the form of donation of books for the library. During the period of October and the first week of November, the Land Registry and the Intellectual Property Office have been relocated to new premises situated in the vicinity of the Salih Moore Judicial and Legal Services Complex. They are open for business and serving the public despite the various challenges that have been encountered. The Land Registry has had great success over the past 3 years, having worked to eliminate a significant backlog in the registration of documents and making its registration processes more efficient. Documents in the registry have been digitized, and the online search function of the Land Administration and Information System, the LAIS, has now been completed and was launched recently. This function allows attorneys at law, their clerks, and other registered users to search the records of the Land Registry in St. Kitts from the comfort of their offices. The process of registering documents online will be available during the next few months. The Ministry of Justice and Legal Affairs is grateful to the government and people of the Republic of China, Taiwan, for their significant investment in the Land Registry. They have given technical and financial support to the land administration system, the building of the LAS platform, and the financing of equipment and furniture. Milady, in spite of the difficulties and the challenges experienced, the trying circumstances that we have encountered due to the COVID-19 pandemic, the administration of justice is alive and well in St. Kitts and Nevis. The court remains an integral part of our nation state, which strives every day to live up to its mission statement, to serve its member states by providing access to a system of justice that is accountable and independent, and administered by officers in a prompt, fair, efficient, and effective manner. We are cognizant of the contribution that the judiciary makes to the socio-economic development of our countries, and we are firm in the knowledge that the judicial branch is an essential guardian and vital enforcer of those fundamental principles enshrined in our democracy. We pray for a productive, a successful law year 2022. May it please the court.
Mr. Dazrian Green is our next speaker, and he comes to us from the Helen of the West Indies, St. Lucia. Mr. Dazrian Green was admitted to the Bar of St. Lucia in December 1999. He began his practice at the private bar, engaging primarily in criminal litigation at all levels of courts in the ECSC for both prosecution and defense. In October 2016, he was appointed as Director of Public Prosecutions for the state of St. Lucia. To address us on behalf of the Directors of Public Prosecutions in the OECS and as the representative for St. Lucia, Mr. Dazrian Green.
May it please you, my lady, I wish to adopt the protocol list that has been so well established. May I be permitted, however, to recognize Her Ladyship, the Honorable Dame Janice Pereira, Chief Justice, Their Excellencies, Heads of the States of the OECS, the Prime Ministers and Chief Minister of the OECS, Judges and Masters of the Eastern Caribbean Supreme Court. I am indeed honored by the opportunity to address this Honorable Court at the virtual opening of this new law year, 2022, on behalf of the Directors of Public Prosecutions. We would all recall that in February of 2019, this Honorable Court changed the date for this special sitting from September to January of each year. This was done to avert the possibility of a spontaneous cancellation of this traditional sitting due to the unpredictability of Mother Nature. The year 2020 ushered in a storm of unforeseen magnitude and duration. The COVID-19 virus is still with us. Notwithstanding global attempts to fend off this deadly virus, the impact of its presence has been felt, I dare say, by everyone in this world, as I strongly believe that every citizen of this planet knows someone who's been directly affected by this virus. In keeping with the theme for this new law year, reimagining the justice system in the era of COVID-19 and beyond, this pandemic has been a catalyst for change in the judicial systems of the member states. Amidst the environment of despair and uncertainty, this virus has demonstrated to us how resilient a people we are. By accepting our new reality and continuing to strive for excellence and the timely delivery of justice to all. Though the pandemic has separated friends, family, and colleagues from the in-person interaction that we all grew accustomed to, it has shown us the clear advantage of the efficient and effective use of our virtual space. We have seen access to justice indeed reimagined in all member states by the implementation of measures such as electronic filing and practice directions that facilitate virtual hearings, thus allowing the wheels of justice to turn at an acceptable speed amidst this crisis. The offices of Directors of Public Prosecutions of the member states and territory no doubt play a vital role in assisting our justice system in its functions. We all have risen to the challenges posed by COVID-19 to ensure the criminal courts within the member states continue to function. Virtual hearings have become commonplace throughout the member states and have proven to be quite advantageous to the case management process of criminal matters. In some member states, the lack of updated ICT devices to facilitate virtual hearings and poor internet connectivity have proven to be common challenges. It is clear, however, that virtual hearings will become the norm in all member states throughout the foreseeable future of this Honorable Court. In many instances, these hearings have proven to be very cost-effective. My lady, this pandemic has led to significant backlogs in the conduct of jury trials. The majority of our member states are without trial by judge alone legislation. In the state of St. Lucia, it is of great concern that the remand population at our correctional facility significantly surpasses its penal. Presently, there are 327 persons on remand at our correctional facility, as opposed to 172 penal. There are over 90 persons awaiting trial for the offense of murder, while we continue to struggle with the difficulty of finding appropriate housing for our courts. Due to the present layout of the courts in the Criminal Division of the High Court in St. Lucia, none of the courtrooms are able to accommodate the number of jurors required to try offenses of murder. This is due to the physical distancing requirements imposed on us by this virus. Consequently, my office has not been able to embark on a murder trial since January of 2020. This situation is not tenable, as we continue to see the increase in our backlog of cases in the criminal division. This is set against the backdrop, may it please you, milady, that St. Lucia in 2021 recorded its highest number of homicides in its history. I remain hopeful that the difficulty in providing suitable housing for the courts will not continue this year, and that my office will be in a position to significantly reduce the number of pending murder trials. Amidst this disappointing situation, it is very pleasing to report that approximately 360 indictable criminal matters were completed during the year 2021. This was achieved to a large extent by the use of our virtual space. My lady, I wish to applaud this honorable court for ensuring that persons continue to have access to justice, notwithstanding the immense challenges presented by this virus. In conclusion, our offices remain resolute in performing our functions in the judicial process to ensure that justice is delivered to all, whether in person or virtually. In the premises, I wish to bid everyone, on behalf of my fellow DPPs, a happy, healthy, productive, and safe 2022. May it please this honorable court.
Our next address will be delivered on behalf of the magistracy by the representative of the Spice Isle, Grenada. Magistrate Teddy R. St. Louis is a graduate of the University of the West Indies Faculty of Law and the Uding Law School. In 1995, he began his legal career at the private bar when he joined his father's law practice and continued there until 2012 when he was appointed as a magistrate. In September 2019, he was appointed as Acting Chief Magistrate of Grenada, Carriacou, and Petit Martinique. To address us, His Honor, Teddy R. St. Louis.
Thank you, Madam Chair. Ladies and gentlemen, I would like to adopt the protocol list which has already been established. However, permit me to recognize Her Ladyship, the Honorable Dame Janice M. Pereira, DB, LL.D, Chief Justice, Their Excellencies, Heads of States of the OECS, the Prime Ministers, Chief Minister of the OECS, Judges and Masters of the Eastern Caribbean Supreme Court. Ladies and gentlemen, a pleasant good morning to all. I am honored to address you at the ceremonial opening of Law Year 2022 under the theme, Reimagining the Justice System in the Era of COVID-19. The global pandemic has caused unprecedented challenges to the work of the magistracy in all 9 member states. In Grenada, in March 2020, all courts were forced to close due to the discovery of COVID-19 virus on island. The courts reopened in July 2020, facing many challenges. Protocols had to be put in place to protect the staff and the public. The courts had to be retrofitted, social distancing had to be maintained, and sanitization became standard. Magistrates had to deal with a huge backlog of cases and increased number of cases filed due to new regulations. From August 2020 to August 2021, some semblance of normalcy returned to the courts. However, by the end of August 2021, Grenada was gripped by a ferocious community spread of COVID-19, resulting in huge spikes in the number of COVID-19 cases. For the second time, all magistrates' courts were forced to make the difficult decision to adjourn hearings. The sudden challenge was how to ensure that the magistracy continued to function despite the necessary lockdowns under the global pandemic. We did not have to look far for a solution to this problem. Our neighbors to the south, Trinidad and Tobago, and Guyana already embrace online technology at the magistrate courts. Our very own CCJ have been utilizing technology to better offer litigants access to justice and enabling lawyers to appear before the CCJ remotely. Sir Dennis Barron, former president of the CCJ, stopped relying on paper and moved to filing systems, and all works to the electronic media, enabling him to access all his work electronically, heralding the shift of the CCJ to a paper-smart organization. Our approach was to form an ad hoc committee involving key stakeholders to explore the possibility of virtual hearings at the magistracy to ensure the public continues to have access to justice. Right after its first meeting, the Attorney General was approached to discuss the introduction of virtual hearings in the magistracy. This suggestion was well received by the Attorney General, who not only endorsed the plans, but gave a commitment to have the necessary regulations in place. I am pleased to report that approximately 5 weeks after closing court, we had moved to virtual hearings in all magistrate courts in Grenada, which commenced on 11th October 2021. This accomplishment would have been remarkable in normal times, and in COVID times, even more so. Lawyers are now appearing and doing matters from their homes and offices, even when they are out of the jurisdiction. Litigants are appearing from their lawyers' offices and their homes. Prisoners on remand are no longer required to appear in person. This has led to tangible benefits. More matters are being disposed of. Fewer adjournments have been requested, resulting in tremendous cost savings. The world has changed, and so too the magistracy must adapt to these changes. The new normal will include the filing of cases being done online, digitalization of court records, e-financial system, the use of electronic court diary, enhanced connectivity of the courts, electronic recording, and better data collection. However, virtual hearings will bring new challenges. Traditionally, magistrates only had to be aware of what happened in the courtroom. But with virtual hearings, you must worry about how evidence is received. Is the digital platform secure? Is someone in the room influencing the witness? Has an electronic document been tampered with? And other unintended consequences. As we embrace technology, we will need to maintain judicial integrity by adhering to the Bangalore principles of equality and fair treatment. I have been advised that Grenada is the first member state to commence virtual hearings at the magistracy. This has been a game changer for Grenada and for the region. It will be remiss of me not to make mention of some of the key persons and positions whose support and forward thinking were instrumental in Grenada achieving this significant milestone. The government of Grenada and Mr. Peter English, the IT specialist, the Attorney General, Ms. Dia Forrester, and her team at the Ministry of Legal Affairs, the ad hoc committee, in particular, Chair Mr. Ruggles Ferguson, the magistrates and staff of the various courts. Special mention must be made of Chief Justice Janice Pereira, who met with the magistrates in July 2020, who urged Grenada to embrace the digital platform and technology. Also, retired Judge of the Eastern Caribbean Supreme Court, Justice Stanley Moore, and the President of Law Association of Trinidad and Tobago, and the Vice President of Guyana's Bar Association, who gave invaluable guidance. I would like to encourage my colleagues to join us in this digital transformation. This is a call to action. The lessons learned is that in these unprecedented times, working in a collaborative manner, great things can be achieved by the magistracy, making the judiciary less vulnerable to pandemics and indeed transforming the way we provide uninterrupted service to our public. I thank you.
Sir Clare K. Roberts, KCN, Queen's Counsel, is our next speaker. He has served as Attorney General of Antigua and Barbuda, the British Virgin Islands, and Montserrat. He is also a former Chief Parliamentary Counsel and Solicitor General of Antigua and Barbuda, former Independent Senator in the Senate of Antigua and Barbuda, former Acting High Court Judge in Anguilla, Nevis, Grenada, and St. Vincent, and a member and former President of the Inter-American Commission on Human Rights. In 2007, Sir Clare was elevated to the rank of Queen's Counsel. Throughout his illustrious career, one of Sir Clare's passions lies in the area of human rights. In 2006, he was knighted for his work in that area and his service to the legal profession and youth. To give the address on behalf of the Inner Bar, and also as the representative of Antigua and Barbuda, please give your attention to Sir Clare K. Roberts, KCN, Queen's Counsel.
I adopt the protocol list which has already been established. However, permit me to recognize Her Ladyship, the Honorable Dame Janice M. Pereira, our Chief Justice, the Excellencies, Heads of State of the OECS, Heads of Government of the OECS, Judges and Masters of the Eastern Caribbean Supreme Court. The COVID-19 pandemic poses challenges for institutions and individuals in our region and worldwide. The justice system in the OECS has not escaped these challenges. It is said, in every challenge lives a greater opportunity. The protocols mandated to save lives, for example, social distancing and mandatory vaccination, hastened the use of distance meetings since face-to-face hearings and trials became impractical and downright dangerous. Judge-alone hearings of criminal matters in the High Court became a reality at least in one jurisdiction, Antigua and Barbuda. Truth to tell, our Chief Justice had already embarked on this road of technology to lessen delay and increase competence. But the pandemic hastened the process and provided justification for the necessity of it. I imagine that the judicial system will continue on its technological path, and the urge to go back to paper will be resisted. A reimagined judicial system is one that is technologically driven. Every effort must be made to bring the same technology at work in the High Court and the Court of Appeal to the magistrate courts in the OECS. This reimagined technology-driven system must be complemented with personnel with updated skills, with lawyers who are aware that in this new dispensation, the law is not to be found in the volumes on the shelves in our conference rooms and law libraries, but in Nexus Lexis, Westlaw, Justice, Carilaw, and the other search engines. I see the bar in our islands being led by a core of young, brilliant QCs appearing before a panel of equally young, brilliant, and technologically savvy bench, really taking our jurisprudence to higher heights as they deal with issues in the era of COVID-19 and beyond. After all, Napoleon was made emperor at age 35. Martin Luther King Jr. was awarded the Nobel Peace Prize at age 35, and Jesus Christ rose from the dead at age 33. The COVID-19 pandemic and the measures necessary to combat the virus and to save lives and livelihoods brought about an intrusion into not only our basic and civil liberties, but also our economic, social, and cultural rights. The justice system must continue to play its part in protecting and propagating the rights declared in our constitutions. The pandemic brought about a very limited consciousness of human rights. There's now a golden opportunity to spread the word about rights. I see a role for the justice system in a mass sensitization about human rights, but also about responsibilities. I see the Chief Justice and her justices using the social media and making television appearances, spreading the message. We need all hands to the plow. And what better hands than those in our trusted judicial system? I am imagining an expanded mandate for the Judicial Education Institute as part of this outreach program. I see the human rights committees of the bar associations in the region, along with the OECS Bar and the OC and ACBAR, giving priority to sensitizing all and sundry in the region as to their human rights and responsibilities. I imagine an abiding trust in the justice system, thanks in large part to the yeoman service of Dame Janice Pereira, our Chief Justice, the justices of appeal, the judges, masters, magistrates, registrars, deputy registrars, administrators at the head office in St. Lucia and in each and every territory. Thank you all. This region owes a special debt of gratitude to our Chief Justice, Dame Janice Pereira, for so calmly steering the ship of justice over the dangerous waters of this pandemic. We have benefited from her creativity and quiet confidence, which have marked her leadership. I also wish to congratulate our Chief Justice on achieving the accolade of being recognized as a pioneering Caribbean woman jurist by the CCJ Academy of Law. I urge all to stay safe and well and to vaccinate so that we all can be alive to witness the workings of the reimagined justice system in the era of COVID-19 and beyond. Thank you.
Our next speaker has a keen interest in continuing legal education and has served as a coordinator of the OECS Bar Association's annual Regional Law Conference from 2013 to date. Ms. Jean Dyer is a former president of the Anguilla Bar Association and has from October 2020 served as the president of the OECS Bar Association for a period 2020 to 2022. She is the second female president of the association since its formation in 1989. To address us on behalf of the OECS Bar Association and as a representative for Anguilla, please welcome Ms. Jean Dyer.
May it so please the court, Milady Ellis, with your leave, I would like to adopt the protocol which has already been so ably established. However, permit me to recognize Her Ladyship the Honorable Dame Janice Pereira, Chief Justice of the Eastern Caribbean Supreme Court, Their Excellencies, Heads of State of each of the OECS member states and territories, Honorable Heads of Government of each of the OECS member states and territories, and Judges and Masters of the Eastern Caribbean Supreme Court. Distinguished guests, colleagues, citizens and residents of the OECS, on behalf of the OECS Bar Association, I extend a warm welcome to all of you to the opening of the new law year 2022. I thank you for your support in watching the broadcast of this virtual event online. 2021 was another extraordinary and difficult year for the OECS and also for the world. The COVID-19 pandemic has continued to take a great toll everywhere. My thoughts and well wishes are extended to all of those who have lost family and friends to the virus. Our court and its operations have also been affected, and thanks must be extended to our court staff across the OECS, led by our Honorable Chief Justice, who have worked so hard in such difficult circumstances to keep our courts functioning. Over this last year, your tenacity and hard work have allowed our justice system to continue working under the unprecedented pressures you face because of COVID-19. Because of these endeavors, our citizens, residents, and investors could resolve a range of disputes despite the various lockdowns. As the world looks to 2022 with hope and guarded optimism that the pandemic will eventually be overcome, the opening of the new law year is an important occasion for the judiciary, the legal profession, and also our communities as it focuses public attention on the administration of justice and the rule of law. Last year, I spoke about our collective responses to the coronavirus pandemic and the impact of budgetary constraints on the rule of law. This year, with your leave, my Lady Ellis, I will touch briefly on our collective response, but I intend to focus on looking beyond, looking ahead, and looking forward. The single most salient after effect of the current pandemic on the legal landscape is its impact on our court. We in the OECS have been hard at work from since in about 2000, building our virtual court infrastructures as part of the ongoing efforts of our former Chief Justice, the Honorable Sir Janice Pereira, to streamline judicial operations and increase access to justice. These efforts were continued by his successors, and as such, we in the OECS were somewhat ahead of the curve in this context. There was nonetheless a wide disparity spectrum in the use of technology in our various member states and territories, primarily due to budgetary constraints. Because of the pandemic, the speed of change has been unparalleled. Some of our circuits have been pushed from hopeful numbers of being virtual, perhaps in a decade's time, to courts functioning virtually within months. Our justice system has prevailed using virtual tools. One such virtual tool is our secure litigation platform, which is now available in all member states and territories. This platform has allowed our court to go digital with filings, case management, and calendaring. The digitization of data, enabling alerts, filings, and all other facets has undoubtedly created a foundation for our court to function more seamlessly. Overall, our justice system has responded well to the pandemic, given the extraordinary circumstances. Our court has continued to plug away with virtual procedures, working out many of the kinks over the past year. The increased use of virtual courts has been said to offer greater access to justice in the OECS. Whilst we've made progress, more needs to be done. Due to the nature of judicial processes, such as in-person participation in criminal and some other trials, our formal justice system is not equipped to fully function remotely in the context of a quote-unquote shutdown. Whilst we've made use of the technology, it's said that some hearings, such as the jury trial, which are used in the most serious criminal cases, cannot happen remotely. In April 2021, the OECS Bar Association held 2 virtual forums wherein we explored judge-alone criminal trials as a solution to this problem. We, however, need to explore other solutions, whether temporary or permanent, that limit the chances of miscarriage of justice and maintain public faith in the judicial system. We have to find ways of getting criminal trials moving at pace once more. The OECS Bar Association is committed to working with our Honorable Chief Justice and our heads of government to find solutions. The coronavirus pandemic has also changed the way the OECS Bar Association has advanced its work plan. The use of technology has enabled us to reach out to more members of the judiciary and lawyers in the OECS. In a way, it is a blessing in disguise. In early July 2021, we, together with UCBA, organized a joint virtual forum on mandatory vaccination, which was attended by some 772 participants. What's more, some of the radio stations in the region also carried this most important discussion live. We at the OECS Bar Association intend to continue with our efforts to use technology to drive professional excellence in the OECS and also to raise public awareness on topical legal issues. Some of our events, which are best conducted in person, however, had to be postponed. One such event is our wellness retreat, which we intended to launch in 2021. During this upcoming year, the OECS Bar Association intends to work to destigmatize mental illness, recommend best practices and remedies, and help bring more balance into our members' daily professional lives. To this end, we intend to introduce an annual wellness retreat in 2022 where members can disconnect and focus on their health and wellness. Milady, these are a few of the activities which the OECS Bar Association will undertake during the course of this year. Time, however, does not permit me to address the others. In closing, I once again wish to thank each and every one of you for joining us to celebrate this important day in our calendar. As far as the administration of justice is concerned, I reaffirm the OECS Bar Association's commitment to continue to safeguard the independence of the judiciary and the rule of law in the OECS. We will continue to speak up without fear or favor. For as Lord Bingham observed in his classic expedition on the rule of law, scarcely less important than an important judiciary is an independent legal profession, fearless in its representation of those who cannot represent themselves, however unpopular or distasteful their case may be. Milady, it only remains for me to extend to all members of the judiciary and of the legal profession the OECS Bar Association's warm wishes and prayers for good health, continuing wisdom, strength, and fortitude for the year ahead. May it so please the court.
Our next speaker hails from the island affectionately known as the Breadfruit Isle. Ms. Renee M. Baptiste, CMG, is a legal practitioner of the Bar of St. Vincent and the Grenadines with 45 years of court. She's a graduate of the University of the West Indies Faculty of Law and the Yielding Law School. During her prominent career, Ms. Baptiste holds the distinction of having a number of firsts. She was the first female lawyer to be elected to Parliament in St. Vincent and the Grenadines, and the first speaker and the first female to be elected to that office in the OECS. To present the address on behalf of the presidents of the Bar Associations of the OECS and as a representative for St. Vincent and the Grenadines, I give you Ms. Renee M. Baptiste.
Honorable Madam Chief Justice of the Eastern Caribbean Supreme Court, Dame Janice Pereira, Honorable Justices of Appeal, Honorable High Court Judges, Honorable Attorneys General, other members of the High Court staff, registrars, legal practitioners, distinguished guests, members of the media, members of the clergy, good day. May it please you, my lady, the cliche is true. We live in new times. In every decade and every generation, changes are expected. We've also learned that change is inevitable. However, nothing could have prepared us in St. Vincent and the Grenadines for two momentous events in last year. Firstly, the stubborn, persistent pandemic and the spread of the coronavirus and its mutations grabbed hold of the whole nation, whilst at the same time, the violent, historic eruptions of the La Soufrière volcano made its presence felt near and far. The pandemic meant that we had to gravitate to more virtual activities and events, creating some new synergies, while striving to have continuity and some semblance of normality. But the movement of goods and people stagnated and suffered. Public transportation affected many workers in several sectors. The eruptions meant instant disruptions of the norm. I must at this stage register our deepest gratitude to the Bar Association of Grenada and the Bar Association of Dominica. Shipments of relief supplies arrived at Port Kingstown within days of the eruption. A distribution committee headed by Mrs. Letitia Sandy Marks did an awesome job of ensuring that relief supplies were sorted and delivered to several centers, along with the help from the staff at the FIU. Special thanks to the Bar Association of St. Kitts and Nevis for their donation, which will be used in the continued relief efforts. A number of legal practitioners here in St. Vincent volunteered instantly at the shelters, providing registration services and other logistical duties, including transport. This was going to be for a little longer haul than we all expected. Thank you also to CMIC for providing storage. Our organization's members contented themselves to attend regional webinars in family law and ACPA training sessions, the ECSC LECPD session, and even at the High Court of India, where mediation training is taking place, as well as online activities of the UWI Faculty of Law celebrations of its golden anniversary. Yet still from the ashes, some green shoots have emerged. The long-awaited e-litigation portal was officially launched, and I've been advised that the practitioners are quite happy with the rollout so far, a few hitches here and there, which is expected. And the news that the government agencies are in the early stages of preparation for the construction of the Hall of Justice, and yet more assurances for the presentation of the elusive legal practitioners bill. I feel at this stage like singing the hit song by Etta James, At Last. Meanwhile, we embarked upon a project to list the UWI graduates to more effectively organize this alumni body. During the year, several practitioners took the opportunity to seek Masters of Law degrees in a number of legal disciplines. Others created even online platforms to discuss legal topics on Bar Talk. The Rule of Law Room Facebook page, created by Counsel Mikhail Charles, certainly in my view deserve an award for being the most active, posting on various topics and subjects, news from around the Commonwealth and our Eastern Caribbean, and indeed the world. Catherine Walters, initiative of the Law Forum, as well kept the notices flowing, the emails from our secretary. Regional cooperation continued with the Impact for Justice project, and we have benefited from a number of their programs, including the proposals for changes in the business names law and arbitration. The Bar Association continues its work with the Ministry of Trade on CSME matters and the Ministry of Labour on Employment Relations and Labour Relations Bill, as well as the Occupational Health and Safety Bill, attending consultations of the Ministry of National Mobilization on Sexual Offences Bill. I take this opportunity to compliment the magistracy on the pace with which they were able to ensure that those courts continue to function without having this instrument. Special plaudits to the President of the Family Court and her staff. They have made the official request for further support of their court, which have our full endorsement. Criminal Sessions also chose not to foster a culture of postponement, even if some practitioners did not expect its adaptability to unfold with such a clarity. Finally, I urge us all to continue to work together, especially in the OECS Bar Association, as things are changing fast. I urge practitioners to prepare for the continued paradigm shift in continuing legal education and continued professional development. I believe this will become compulsory much earlier than we all expect. All the subcommittees would be expected to fully function in 2022 as we begin afresh and new leadership takes over. We thank the magistrate courts and their staff as well, the honorable judges of the High Court for their forbearance, and the staff of the High Court Office and the registry. Many appreciate the difficulties in your situations and trust that mutual cooperation would continue. I offer apologies to our honorable judges who have been most patient with this shift and that all have had to endure in our special circumstances. However, I am one that is constantly assured by prophets of old with their counsel that there is always light at the end of the tunnel and that the darkest night must give way to the newest bright dawn. Thank you very much, my lady. Much obliged.
Our next speaker comes to us from the territory of Montserrat, also known to some as the Emerald Isle of the Caribbean. Mr. Horace Sullivan has been a practicing attorney in the territory of Montserrat from 2004. He has worked in the Attorney General's chambers and also as Senior Crown Counsel at the Office of the DPP until he was appointed as acting DPP in 2013. He was confirmed in that position in 2015 and today still serves in that capacity. Mr. Sullivan is also currently the president of the Montserrat Bar Association, a position which he has held for the past 2 years. To address us, as a representative of the territory of Montserrat for the Utter Bar, Mr. Horace Sullivan.
I would like to adopt the protocol list which has already been established. However, permit me to recognize Her Ladyship, the Honorable Dame Janice M. Pereira, DBE, LL.D., Chief Justice of the Eastern Caribbean Supreme Court, Their Excellencies, Head of State of the OECS, the Prime Ministers, Chief Ministers and Premiers of the OECS, Judges and Masters of the Eastern Caribbean Supreme Court. The theme is Reimagining the Justice System in the Era of COVID-19 and Beyond. It was Don Mitchell, retired Justice of Appeal, who wrote, "If our judiciary is to maintain the respect of our societies, the traditional judicial qualities of impartiality, independence, and integrity will need to be maintained and strengthened, and new practices will have to be adopted. The modern West Indian judge will increasingly be called upon to adopt old principles to modern realities. Judicial impartiality will increasingly be challenged by the modern ethic of corporate marketplace efficiency. Judges will be called upon to practice management reforms, show more effective use of resources, be more responsive to the needs of society, and more accountable for their actions. We will be asked," he said, "about our performance results, and be subject to program-based budgeting systems, all imposing a greater risk of political direction." In Montserrat, as much as things have resumed some semblance of normality, the COVID-19 pandemic has had a profound impact on work at all levels, and the legal profession is no exception. At its inception, the near universal transition to remote work was unprecedented. It created daunting technological and logistical challenges for legal practitioners. Lawyers, staff, and employers has had to devise new ways of keeping teams connected, engaged, and productive. We were forced to grapple with the economic consequences of the pandemic, including meeting often pressing demands by clients for legal services and implementing cost-saving measures. Individual lawyers made substantial adjustments to deal with the new normal. Lawyers, like everyone else, began working from home at the same time that there was a lack of childcare, in-person schooling, and ready access to the myriad of social, household, and personal services that were routinely used. Juggling both professional and family obligations under these circumstances was extremely difficult, and this was particularly true for women with children. The transition to remote work has also been challenging for most senior lawyers who were unaccustomed to working from home. The considerable stress and anxiety caused by the pandemic, coupled with the sense of isolation as a result of not being in the office, has created well-being and health issues. This extended period of remote work has had transformative and far-reaching impact on the legal profession. No one can predict in a vacuum what the post-pandemic practice of law will look like. That said, one of the most prominent effects of the pandemic was the merging of work life and home life. It should be no surprise that the place of work has markedly changed for large numbers of lawyers. The practice of law entails many stresses and strains, some of which are under a lawyer's control and some of which are not. We will all face clients who can be demanding, tensions with colleagues, second-guessing about the quality of our work, worry about billable hours, and a myriad of other worries. Looking to the future, we ask these questions. Is it feasible to return to largely office-based work? What health and safety concerns are likely to remain? What technical resources will be required? What will the economics of post-pandemic law practice look like? How would firms, law departments, and other legal employers provide the practice support and personal support that lawyers are demanding? It is clear that lawyers have already accepted a number of changes that took place in the past year and are not likely to seek to return to many of the pre-pandemic policies and practices. In spite of an expectation of some aspects of remote working, majority of lawyers anticipate that there will be substantially less need for office space. Balancing a number of factors, we will not be surprised to see law firms taking a more serious look at the use of their space and dedicated private offices. At the same time, lawyers have strong feelings about the technical resources needed for the post-pandemic practice. Again, I quote Justice Mitchell. He went on further to write, "In just a few years' time, no lawyer will employ a messenger to attend at the courthouse to file a paper, claim, or defense. This will all be done automatically by accessing the registry online. The court registry will be replaced by the cloud." We are not there yet. Already, most modern West Indian lawyer offices do not house a single textbook unless it is for decorating the walls in the conference room. In the modern law firm, all legal research is now done online. There are things that lawyers have traditionally done that can be animated today. Artificial or augmented intelligence, AI, is coming to the practice of law and the determination of disputes. There is no sense fighting it, he says. He was writing at a time when no one had an idea there would be a pandemic and a seismic shift to the new realities that pertains today. Justice Mitchell's words can be proclaimed as being prophetic as we are at that stage now. I close by saying this. We have been fortunate here on Montserrat. The courts have resumed in-person hearing in both the High Court and the Magistrates' Court. Lawyers are now back before courts and practicing law the traditional way. How long would this last is everyone's guess, as there seems to be no end to the pandemic. In any event, some of the practices developed during the pandemic will remain. I eagerly look forward to see what the future holds. Finally, I take this opportunity to remember our fallen colleagues who left us during the pandemic. Mary Roach, Hogarth Sargent, and Carl Markham are no longer with us. May their souls rest in eternal peace, if it pleases you.
Our final speaker is from the Nature Isle, the Commonwealth of Dominica, in the person of Mrs. Noelise Knight Didier. Mrs. Knight Didier has been a practicing attorney since 2003 and has been a partner at the firm Harris and Didier in Roseau, Dominica since July 2013. As a trained and certified arbitrator and mediator, Mrs. Didier has been a member of the Chartered Institute of Arbitrators since 2015 and on the roster of mediators for the Eastern Caribbean Supreme Court from October 2019. To address us on behalf of the Utter Bar and as a representative for the Commonwealth of Dominica, Mrs. Noelis Knight Didier.
Many thanks to the court. And may it please the court, I wish to adopt the protocol list which has already been established. However, my lords, please permit me to recognize Her Ladyship, the Honorable Dame Janice M. Pereira, Chief Justice. Their Excellencies, Heads of State of the OECS, the Prime Ministers and the Chief Ministers of the OECS, Judges and Masters of the Eastern Caribbean Supreme Court. Good morning, and I bring warm regards to the court and to all from the Nature Isle, Dominica. It is my distinct honor to present this short address on the occasion of the ceremonial opening of the Law Year 2022 from the perspective and on behalf of the Utter Bar, along with my colleague, Mr. Horace Sullivan. As others before me may have intimated, the past year, like the year before it, has been a challenging one for practitioners as we continue to cope with the onslaught of COVID-19 on the entire world. However, while in 2020 practitioners were still getting their feet wet with the technological changes brought on by the COVID-19 protocols, in 2021 we operated with greater fluidity and efficiency. We cannot reiterate enough as practitioners our appreciation to the court headquarters under the guidance of the Chief Justice, Her Ladyship Dame Janice Pereira, and to the various registries for how quickly and efficiently the court was able to implement its own protocols and transition into virtual court when the pandemic hit home in 2020. And last year, as we moved into the second year of this new normal, court matters continued and still continue to move smoothly and with alacrity. My lords, when relating to a client recently about the transition of court hearings to the Zoom platform, or what we like to call Zoom court, and also the introduction of e-filing, the client was quite impressed and then asked, "So do things move faster now?" My lords, I responded, "Have no fear, soon to come." And indeed, we do look forward to this inevitable progression of the greater use of technology in our court system. That being, among other things, far fewer logistical delays, fewer cases of lost or destroyed files, and less adjournments due to counsel being out of state, which is no longer an excuse. It even leads to more efficiency within our own offices, in that we can quickly access files on the e-portal, and also we no longer have to sit waiting in the courtroom for the hearing of our chamber or master's court matters, but can now attend to other matters within our offices while we wait. Additionally, my lords, the credence given to the use of technology by the court itself has led to greater acceptance and, consequently, widespread use by practitioners of technology and software that had existed for some time now. Some of these are the sharing of documents via an online drive, collaborating on documents on a virtual platform, and just more frequent use of email rather than physical letters, even for formal correspondence. Having said all of this, my lords, I would venture to say that there is a feeling that a balance must still be struck with technology. Not all litigants are au fait with it, and these litigants cannot be left behind. Accommodation must continue to be made for them. Further, not one practitioner that I have spoken with on the topic has said that they prefer the online platform for an open court trial or for appeal matters. There is a certain je ne sais quoi about operating in the open courtroom for such matters that simply cannot be replicated in the virtual platform. And really, while we enjoy the lawyers' WhatsApp chat group that we practitioners in Dominica, and I'm sure other states, have come to use so much more now for social interaction, it simply cannot replace the physical social interaction among counsel that takes place when we meet up at court, at a meeting, or just run into each other at the registry. Yes, we actually miss each other. So, my lords, as we applaud the court for its quick action in using technology to keep the wheels of justice moving, and as we embrace those technological advances, thereby even fortifying our ability to deal with pandemics, natural disasters, and the like, we are and must continue to be mindful of our humanity. Let us ensure that no one is left behind by technology, and we look forward to the day that we may safely resume live interaction and personal contact for the sake of our mental and social well-being. My lords, it is left just for me to wish the court, colleagues, and all a safe and successful year ahead. May it so please the court.
This brings us to the end of today's proceedings. As we come to a close, I take this opportunity to thank the Honorable Chief Justice, Dame Janice M. Pereira, for her inspiring feature address, and to extend thanks to all of our speakers who addressed the court this morning. Special gratitude is extended to the agencies for public information and the government information services of each of the member states and territories of the OECS, as well as UWI-TV for providing the technical and production support which made this special sitting possible. I also wish to thank all of you for taking your time to join us to commemorate the opening of the Law Year 2022. As the COVID-19 pandemic continues to linger throughout the OECS and the world, I wish each and every one of you a safe and healthy Law Year 2022.
Court rise. Supreme Court in its special sitting to mark the opening of the law year 2022, this honorable court now stands adjourned, sine die.